All right, we'll remind everyone on our panel to go ahead and mute when you're not presenting. And good morning, welcome back. This is Tasha Davenport. I'm Executive Director of CASBO, and I thank you for joining us again today as part of our CASBO Summer Speaker Series. Today, we're joined by Lozano Smith, one of our long-term partners here at CASBO, providing us some guidance and insight on this important topic of the Civic Center Act and fielding those facility requests. So they're here to help you understand obligations around that important topic. So today I am joined by Kelly Rem from Lozano Smith, also Sean Van Wegenen, sorry Sean Van Wegenen, Senior Counsel for Lozano, Kelly, partner there at Lozano, and then Sarah Bachez, our Chief Governmental Relations Officer. So they're your team today of resources. We are recording the session. The presentation is in the Q&A box if you're looking for the actual slides. We will be facilitating, Sarah will be facilitating a Q&A towards the end of the session. And so load up your questions. We'll get them answered by these experts. And if not, we'll find the answer for you. Thank you. I'm turning it over to the Lozano team.
Well, good morning, everybody, and thank you for attending. We appreciate you taking time to join with us. We have up here the agenda. So just so that, you know, we're going to start off talking about the Civic Center Act generally, what the requirements are, and then talk about how that applies now. We're kind of unfortunately today we're going to have a lot more questions and issues to bring up than answers. We are in uncharted territory. During the spring when we first had all the school closures, for the most part, a lot of schools were not making their facilities available to the public. So now as we're starting up school, whether that's distance learning or in person, we've kind of restarted the potential Civic Center Act requests. And so this is something that it's on the forefront of a lot of people's minds, questions we've been getting a lot of lately. So we're hoping to at least kind of talk through some best practices, some considerations you should have. Unfortunately, we can't promise you answers at this point, but we can at least kind of talk through some of the issues that you may be seeing or that you are seeing right now. So turn the time over to Kelly. She's going to kind of talk through some of the Civic Center Act basics here.
Great. Thank you, Sean, and thank you, CASBO. So we're going to start with Civic Center Act basics just because we kind of have to set the stage for the rest of our discussion today. We're not going to spend a lot of time on the nuances of the act itself, and you'll see it says in 90 seconds or less. So let's see if we can do it. Okay, so starting with kind of just the general purpose of the Civic Center Act. First of all, for anyone who is not familiar with the act, it's in the Education Code starting at section 38130. And there's a whole bunch of sections there that talk about use of school facilities. The purpose of the act is to make school buildings centers of free public assembly. So since 1917 in our state, the law has generally required school facilities to be available for use by the public. And what the law specifically says is that there is a civic center at every public school facility and public school grounds. So we're going to be talking both about the buildings as well as, you know, play fields and grounds as well, where citizens, parents, and other groups may engage in recreational activities and meet to discuss subjects and questions in educational, political, economic, artistic, and moral interests of citizens. So that's kind of just the general overview of the purpose of the Civic Center Act. Some things to note, kind of again, to guide our discussion today. The Civic Center has certain groups for which school districts may provide use of facilities, as well as other groups where school districts, according to the statute, must provide use of facilities. So the may is kind of the discretionary group and includes a whole bunch of different types of uses. What we'll call mandatory, although I'm using that word very loosely because we're going to talk about some limitations that school districts may be wanting to place on use during this time. But those mandatory groups are nonprofit organizations or clubs and associations that are organized to promote youth and school activities. So it's essentially those groups that are kind of promoting your students and youth in the community. And examples of that would be Boy Scouts and Girl Scouts, YMCAs, parent-teacher associations, and things like that. So under the statute, those are kind of the mandatory groups that are allowed to use school facilities. You can go to the next slide. Great, thank you. Okay, so this is going to be important in the Education Code. This is part of the Civic Center Act at 38131B. The statute says that the governing board of a school district may grant use of school facilities or grounds upon terms and conditions that the board deems proper, subject to limitations, requirements, and restrictions set forth in the article. So in other words, school district boards have some flexibility to impose terms and conditions on use of their facilities. And as the statute makes clear, you're subject to the restrictions in the law, but otherwise there is room for a lot of flexibility here. And this is going to be a really important section for purposes of our discussion today, because it's one of the areas in the law that will give the board authority to think through these issues and impose appropriate, assuming that they want to make school facilities available at all, which we'll get into. This will give them the authority to be imposing whatever terms and conditions are deemed necessary in order to protect the district itself, as well as students and other users during the time of the pandemic.
Yeah, and I think another important piece in here is, we have the fee schedule. This was changed a couple of years ago to require school districts to establish a specific fee schedule. And really the goal here is for the district to recoup costs associated with Civic Center Act requests. And not to make a profit. And so it can be somewhat of an accounting hurdle to get through to be able to calculate these costs. And we won't get to that today, but we just mention it here because one of the items we'll discuss here shortly is whether we'll charge additional costs to cover maintenance or cleaning. And so just to be aware, there is typically, each board would adopt the fee schedule. And so we'll need to consider how that would fit in with potential modifications. So as we go to the next slide here on the third-party use, the tricky part about this is we have the Civic Center Act. And at this point, we have, we're currently in a declared emergency, both at the federal, state, and many counties have declared emergencies. And so how does a Civic Center Act fit within this? And we put here a big caveat that this is something that you should really be discussing with local health department. I'm here in Central Valley, specifically Fresno County, that has really ratcheted down more so on school use and going forward. And we've been designated a hotspot both by the governor and by Dr. Fauci and the CDC. So the rules here may be different. Kelly Rim, she's speaking from the Bay Area and the 5 counties there. So the rules can be a little different. So it's something that should be considered with your local health department and federal, state guidelines. And then also it's worth reaching out to your risk management. You want to make sure that you have insurance coverage. We've seen a lot of proposed addendum to facility use agreements that they've prepared, and so they may have some good resources for you to start with. So that aside, really there's 3 options that we've been seeing here that districts have considered. And again, there's not a lot of legal authority to fit within these 3 options and how to choose them. But the three that we've mainly been seeing is temporarily suspending all third-party use, limiting use of designated facilities, or modifying facility use agreements, either preparing a new agreement or having an addendum to existing agreements in order to protect the district. We'll talk more about, social distancing, additional fees, those kinds of things. But these are really the three main options to consider. Temporarily suspending, a lot of districts were considering this, particularly before they knew they were going to be going to distance learning. And so they knew that if kids were going to be on campus, they wanted to eliminate the amount of potential exposure to the virus. And so by having third-party use of the facilities, they knew that that meant that when the kids were on campus, that there may be more exposure here. If for districts, the most of the state that we're transitioning to distance learning, that this may be less of a concern, but to the extent you do have staff on campus, there may be a justification for temporarily suspending third-party use. The other option is to limit use of designated facilities. So oftentimes maybe the cafeteria, areas where there's a lot of things to be touching, maybe playground equipment, areas like that. Districts have considered fencing off or not allowing third-party use of those areas. And then the third would be to continue to allow but to modify the agreements. And each of these three, they're not necessarily mutually exclusive. You could temporarily shut down use of the gym and maybe you just open up play fields, and you modify your agreement. So we don't necessarily mean that these are the only three options out there or that you have to pick one of the three, but these are kind of the three discussion items. And on the next slide, we kind of outline that the governor's issued a lot of executive orders, but at this point, none of them have really addressed the Civic Center Act. We have, the Brown Act that addressed public meetings and what those look like, a lot of other modifications, but this in particular has not been changed. So that being said, there are some policies that school districts can use to help guide their decision. First one is board policy 3516.5 if you use CSPA model policies. And this should be a policy that was probably very unfamiliar to most until about March of this year. This is the policy that allows a superintendent to close schools. This was the authority that a lot of superintendents use to shut schools down on, it was a March 16, 17, kind of in that time frame where, we had a real quick surge to shut down most schools in the state. And so that it also talks about taking necessary action when an emergency warrants. So this could be used as this board policy could be used to give, potentially superintendent authority to shut down portions of school use or modify facility use going forward. The other policy is, again, CSPA model policy 1330. And this is what Kelly mentioned earlier, that under the Civic Center Act, the school use is first priority, right? So the schools have the first priority to be able to use soccer fields, classrooms, gym, whatever the facility is, and the rest have the option to use it on a first come, first served basis. And so again, this policy could be a justification for suspending or modifying third-party use, particularly if you're going to have students or staff on campus, because you want to eliminate or at least minimize the potential of the virus being on campus. And so if you had a Little League game and then later on, a couple hours later, you had staff on campus, that's more potential exposure to the virus. So not exactly on point, but it is, an authorization to consider. The other thing is whether board action has been taken, particularly if your board adopted a resolution around the time of school closure or subsequently, that could be authorization to, that something in that resolution, you may want to look at it. It may address Civic Center Act or use of facilities. It may delegate authority to the superintendent. So something worth considering. And then the final piece is your comprehensive safety plan. That would be, we have the ed code sections here in the PowerPoint that would be required. if part of your safety plan addresses third-party use, we've seen a couple that have, that may be justification for deciding how to treat your civic center. The short of it is, again, the point of the Civic Center Act is that we have these giant publicly funded facilities out there that in some communities, especially more rural areas, these are really the primary areas to gather and to use playfields and exercise, and so becomes a big policy decision for school districts on how to treat these facilities. Do we allow public in? And we'll talk more about them later. So turn the time over here to Kelly to kind of summarize some of the considerations to if you are going to allow some third-party use of your facilities.
Great, thanks, John. So just to kind of segue here to the next section, where we're going to talk about protocols and procedures to consider updating. I just kind of want to pause for a second and talk a little bit about where we are. So I think at the end of the day, there's a lot of different options here, and it's really going to be dependent on your district's goals, circumstances, the different rules that may be imposed in your county, as well as how they may be interpreted by county public health officials. We're getting word that different rules are being interpreted differently in different counties. So Sean and I are looking at different things, just even between the two of us here. And then the other thing I think that's really important that Sean mentioned to keep in mind is just coordination, because the decision whether to continue allowing school facility use by outside users and to what extent to allow that use, it really involves a lot of different considerations related to liability and insurance. And that's where we think bringing in your JPAs, talking to your insurance representatives is really, really important. And I'll come back to that in a minute as well. Also, what I'm going to cover on this slide is the importance of this being a board level discussion and not something that district staff is just kind of making up the rules as it goes along. And I'm sure you all can appreciate that. But if you look at the statutes, they all refer to the board allowing use and the board imposing limitations. And so I think this really does need to be a board level discussion. And we've had some really, really great, actually open dialogues lately with school boards in public session, where I think it was helpful for the community to kind of hear the reasoning behind, some of the board's considerations and concerns, because we've had situations where third-party users might not be happy that they're not being allowed to use school facilities to the same extent they were previously. And I think having those communications and being as transparent as possible, of course, while still protecting things that should be attorney-client privilege, is really important and can be really, really helpful. So that's my long-winded way of saying I think that coordination with lots of different stakeholders and interest groups in this process is really, really important. So now we're kind of going to talk a little bit about the scenario in which districts are planning to, to some extent, open their facilities or maintain their facilities open for use by the public, and just some things to consider. So I mentioned this code provision earlier, which is in the Civic Center Act, that allows the school board to adopt rules and regulations to provide for the preservation of order on school facilities and grounds and protect school facilities and grounds. So we think that we've used this in the past pre-pandemic as authority to impose all kinds of different restrictions on use of school facilities. So it does allow for a lot of flexibility. Possible that you could even say it allows the board to restrict use of school facilities in order to preserve order. That's not tested, but I think that's certainly an argument that would be an interesting one to chase down further. Just again, a reminder, it's the board that's supposed to be adopting the rules and regulations. So you do want to make sure that you're having your board look at your policies, your fee schedules, and making the updates that you might be considering based on what we're going to talk about. And one of the reasons for that, not only is it statutory, but we also get concerned about disparate treatment issues. So you want to make sure that whatever policies are put in place, whatever rules and regulations are put in place, that similarly situated groups are being treated the same. And that can prove more difficult, especially in this particular time frame where we're more limited in our ability to open our school facilities. If we can go to the next slide. Thank you. So we're going to talk a little bit about some examples of possible restrictions. And this is really where I personally have spent a lot of my time in the past few weeks working with school districts on allowing use of facilities, but updating their facility use agreements to provide additional protections to address the current circumstances. And I'll reiterate again and apologize for sounding like a broken record, but this is going to depend on the individual circumstances of your district. That will mean what your risk manager has to say and what your local county officials have to say. And there are differences from county to county, and even in terms of how the governor's orders apply to each county. So all of this will depend on kind of where you are. It's also evolving. So the other thing I really want to kind of plant a seed for all of you is flexibility. We want to be careful not to lock ourselves into a use that may be prohibited next week by another order from the governor. So let's talk about a few more specific items that you might want to consider adding to your or tweaking in your facility use agreements if you are going to be allowing use of facilities. So the first one is Sean mentioned earlier on that the Civic Center Act allows school districts to charge fees for use of facilities. And again, this is kind of beyond the scope of our presentation today, but there's a couple of different types of fees that can be charged. One of them is direct costs, either capital or operational costs. And one of the things that's included in all of that does relate to cleaning of sites. Because we're dealing with a pandemic and communicable diseases, that could be an area where additional fees might be warranted. And so that could be one thing to look at. There may be others as well, depending on the circumstances, but that's certainly one that we see a lot of focus on right now. So you might want to look at that. And that ties back again into your fee schedule. Most of your districts probably have or should have an adopted Civic Center Act policy that outlines what the fees are going to be. And so back to board action, we would want to bring that back to the board to adopt an updated fee schedule to take account for that, as opposed to simply imposing it arbitrarily on a particular user. So that's just one thing to think about. Second bullet up there, reserving the district's right to cancel or modify use. I personally think this is extremely important right now because, again, we all sound like broken records when we say these are unprecedented times and things are evolving very rapidly. As Sean mentioned, back in March, things were completely different just in terms of how we were thinking about use of school facilities. We had no idea that we would be starting the school year with circumstances the same, if not worse, than they were back in March. And so we just don't know. We don't know if there's going to be a vaccine tomorrow or if a year from now things will be exactly the same or, God forbid, worse. And so we really want to make sure that we preserve the district's right to be flexible and to act in accordance with the best information available. And so I personally like the idea of having a termination for convenience clause in your facility use agreements. That basically means if some complication arises, if your district gets word that the district next door was sued based on a claim of a COVID outbreak, and the district just wants to pause facility use at that point, it's really nice to have a clause in your contracts that allows you to do that. Short of that, we've also added clauses that would allow districts to terminate use of facilities if required to comply with any applicable order. So if tomorrow the governor comes out and says nobody can enter a school facility whatsoever, that would be an example of an order that would allow a district to terminate under that type of a clause. And then, of course, you always will have a clause for a breach of the agreement, which is important here because most likely we're going to have some important safety-related, compliance with law-related clauses in those contracts, and we want to be able to enforce them by terminating use if we find out that those requirements are not being met. So I think that's a really important consideration for these agreements. Another very important one, of course, is indemnification and insurance requirements. So again, we want to make sure that the users of our facilities are contractually bound to comply with all applicable laws, health and safety mandates, etc. If they fail to do so, we want to have the strongest possible indemnification that we can so that that third-party user is indemnifying and defending the district in the case of any lawsuit. That's really going to be one of the most important clauses for purposes of protecting and insulating the district from liability. And, realize, and I won't go into too much detail on this here, but do realize that these clauses are probably always going to be a little bit limited in terms of how much protection they can provide. Again, there's a lot of uncertainty right now with this pandemic. And there is a clause in the Civic Center Act that talks about delineating liability between the owner of the property and the user of property. And the extent to which that burden can be shifted is a little bit dubious. But there are also some immunities at play that may protect the district as well. So bottom line to say, lots of uncertainty. You want to make sure you have as rock solid of indemnification as possible. And then with insurance requirements, that's going to be an area where absolutely you'll want to be talking to your risk management, your JPA, to determine what's covered and what should be required in the agreement. And this is an area where we've seen some interesting nuances arise. One is to be aware there are exclusions in many policies for communicable disease related claims. So that's going to be an important consideration for you all. You definitely want to talk to your insurance providers about that. We've also seen situations where the insurance or the JPA is asking districts to attach a very detailed onerous addendum, to their facility use agreements that would basically place all kinds of restrictions and requirements on the user of property. And that's an interesting one. I'll pause on that just because on the one hand, we probably don't mind including those riders because they protect the district. On the other hand, from what we've seen, no user would really ever want to sign off on what those riders actually say. They're very onerous requirements in some cases. That could work both ways for the district. On the one hand, if the district really wants to allow that user and the user doesn't agree to the rider, that's a problem. On the other hand, if the district is looking for ways to limit use of its facilities, this might be a little bit of an out in a way. It could be a win-win in the sense of, look, the insurance company is requiring us to include this rider. We have no choice. We have to listen to our carrier. And unfortunately, if no one's going to agree to that, but the board doesn't want to have to come out and say, no, we're not allowing use of our sites, that might be a potential win, actually, even though it seems like an onerous requirement. And then the last thing, I kind of already touched on this, but requiring compliance with applicable health guidelines. So in our template facility use agreements that my firm prepares, we always have a paragraph that says compliance with law, and it says that the user of facilities has to comply with all applicable laws, and that means federal, state, local, board policy, regulation, et cetera, and we make it very broad. Most likely that clause is going to cover the current health and safety mandates and orders that are coming down from the county public health officials. But just in case, just to make sure, since we have this known threat out there that we're all dealing with, we've been adding in language that expressly says, not only do you have to comply with all law and without limiting that in any way, we want to make sure you're aware that you, user of our facility, are on the hook to not only be sure you're aware of all of the latest guidance that's out there, and also that you're complying with all of that guidance. So that can be an important thing to add to your provisions as well. And of course, make sure that your indemnification provisions will cover a breach of those sections. And the last thing I'll leave you with on this slide, and then we'll turn it over, I'll turn it back over to Sean. I just want to say, we deal with the Civic Center Act. Sean and I have been dealing with, and others in our firm have been dealing with the Civic Center Act for years. It's not a new thing. And a lot of what we're talking about right now is applicable all the time. I mean, of course, you want to have strong indemnification requirements and you want to think about specific circumstances. We're kind of focusing on some of the areas that you really want to look at in these times if you are allowing users of your facilities, given that we have this known threat. But I just want to say that someday, if life goes back to normal, a lot of what we're talking about today can be important, just in general or in response to whatever circumstances we might be facing in the future.
Yeah, and that's a perfect segue, I think, to the next point of, Kelly's already kind of addressed, is board action required to modify or suspend facility use? And, legally, we referenced earlier a couple board policies that potentially authorize temporary suspension of facility use. But as Kelly mentioned here, this is such an important, it has become such an important issue with the current pandemic. We're at a spot now where a lot of parents and communities feel somewhat helpless as we're, dragging into the 5th month of, combination of shelter in place and not having schools. And there's a lot of gyms are closed and parks are closed. So, there may be a lot of political pressure and frustration that boards and school districts may experience if you decide to just close all facilities altogether. There's people have a strong desire to get out and to have a spot to exercise or to get together or to worship or whatever it may be. And so by taking that away from them, there could be a lot of frustration. So whether or not board action is required, either way, it may be a good practice to have a board meeting where there's a potential for public comment. People in the community could express their desire. Ultimately, it would be the district or the board's decision on what you want to do and what's best for your district in conjunction with local health guidelines, consultation with your JPA or insurance carrier. But having that public outlet can at least help address some of that concern, and people would have the opportunity to feel like they were contributed and expressed, their frustration was heard. And then also this can be we've seen, as Kelly mentioned, the Civic Center Act's not new, and the Civic Center Act can be an area of a lot of frustration, even with the pandemic apart. We've seen a lot of fights over little leagues competing to use certain fields, and this is something that citizens as taxpayers have the right and feel the need to use these facilities. So it can be something that if a decision's made at the administrative level, a lot of times the board may be the ones experiencing the heat from that decision. So it may be worth considering taking this decision to the board. It could be part of your comprehensive safety plan, your reopening. And then also, we've talked a lot about modifications. Kelly mentioned, 5 or 6 modifications that you should consider making. We also talked about modifying the fee schedule to be able to recover some of that additional cost if you're having to sanitize, clean, or provide additional equipment to make the area safe. And so if you're considering charging an additional fee to recover those costs, then at that point, adopting a resolution, giving some direction to the superintendent or delegating authority to modify facility use during the pandemic could be helpful. That being said, you may want to look at your original resolution to see what was adopted there, to see if you're already covered. All that to say, there's a lot of considerations that we've talked about this morning, and taking that to your board and having a public outlet could be a good option to consider. The next, we kind of want to talk through some of the most frequent questions we've been getting here, and kind of some specific examples. The first of those is what to do with Civic Center Act requests as they relate to churches. We talked earlier on that there are different kinds of entities that may request use of facilities, and you have some that may request use and some that are entitled that the district shall authorize them to use. And so for the most part, the required entities, those are youth organizations. So your Boys and Girls Scouts, your Little League, assuming they charge only a nominal fee, and those have a stronger entitlement to use your Civic Center Act, your civic centers, versus other public groups or churches. It's a may. That being said, there are constitutional considerations here, and what you want to be careful of is any attempt to single out churches in particular could be more susceptible to a challenge under the constitutional freedom of religion. So, but if you're adopting a policy that's, facially neutral, meaning it applies to everybody, if we're requiring everybody to comply with the county guidelines, and the county guidelines don't allow religious services, then you're not singling out, religion or churches, you're applying it universally to everyone. And so for a lot of counties on the governor's watch list, indoor services have been suspended, but in some cases they have been allowed outdoor services. So it may be something to consider whether you allow, use of football field or other outdoor area for these sorts of requests. And so again, the goal would be to be more, facially neutral. You're not picking on a particular user. Here we're talking about religion, but that would apply generally to, you don't want to necessarily prohibit little leagues or, any type of user. Instead, you would regulate the facility. So you're not allowing use of a gym or a particular area, and then requiring all to comply with local health guidelines and CDC guidelines. So.
Yeah, and just to jump in on the childcare on the prior slide. So this is another area that we're getting just lots and lots and lots of questions about, and that has come up just in the past few weeks or couple weeks even, as school districts who were thinking they were going to be reopening for in-person learning learned that they were not, and lots of parents are scrambling. I'm sure we all, probably many of us on this call, are experiencing that ourselves, or else we know people who are. And so a lot of districts that we work with are trying to find ways to help, particularly their own employees and teachers with childcare needs, but also essential workers, et cetera. And I guess what I'll say here is I can understand that sentiment. And so we try to work with our clients on that, but do realize that there are a lot of implications here related to opening your facilities for childcare right now, as well as just, proceed with caution and make sure you're involving all of the different stakeholders in the conversation, including your attorneys. But some of the main things to think about are just, the health and safety mandates and the indemnification. They kind of take a different meaning when you talk about the fact, or think about the fact that it's actually going to be your own students, potentially, not always, but some of your own students that'll be on campus. Do realize, again, we mentioned that sometimes the specific orders vary by county, and sometimes the way they're being interpreted vary by county. We've heard, I believe, down in the Central Valley that public health officials are essentially saying you can't have childcare on school sites during distance learning because they would be essentially in school. Up here in the Bay Area, we are not hearing that from anyone. We have not so far heard that from any of the county officials, but we are advising everybody to make sure that if they're entering into a childcare situation, that they are consulting with local health officials to see, because again, you just never know how somebody might interpret something, as we see changing rules all the time. So just this is a whole other can of worms, I think, with the childcare, but I think it's a big issue right now, and I think it's just important to involve lots of different representatives in the conversation and realize that there's a lot of issues to navigate.
Yeah, a lot of issues here in Fresno County is, we've kind of gotten direction from Fresno County that's not allowable. So, it makes it a lot more difficult, or I guess in some ways it makes it easier because the answer is no. Then the fourth point here that we've had a lot of requests from is that, what do you do with our facilities that are open? And so this kind of depends on your school sites. There are some schools that have the entire campus fenced off and they keep them closed, gate locked when school's not in session. There are other schools that there's some common areas that either the gate's left open when school's not in session or it's not fenced at all. And a lot of times that's your track, your football field, some grass areas. And so we've had a lot of requests of what do we do with these facilities? And we just point out here, first of all, that this isn't a Civic Center Act issue, because the Civic Center Act is really specific to requests by entities for public use. it's not just being open and available for public to come in and use the facilities. So we're not really talking about the Civic Center Act here with this particular issue, but it is a very important issue to think through. And again, the answer has been, it depends. Lots of consultation with local health officials. And we've seen a variety of issues. Some schools have closed off, they're not allowing public to come in and use the soccer field or the track or to come out and exercise or to play. Others have left them open, and they've considered either locking bathrooms, turning off water fountains, we've seen a lot of caution tape around, maybe the jungle gym in the middle of the play fields, but by the elementary schools. Those have all been considerations that we've seen. But ultimately, if you are going to have a discussion with your board or as part of your Civic Center Act or your policy to your facility use agreements, it's worth considering how you want to treat your facilities or your fields open to the public. Do you want to make those available? Again, in a lot of towns across the state, parks are closed, gyms are closed. You have people living in apartment complex that don't have a lot of green space available. So there has been pressure to make that available so people can get out and, exercise and have some sense of normalcy. But you may want to just, consider, is it worth providing that service? What's the liability that you're going to potentially have by allowing people to come? And that's going to depend on what your guidance from local health officials. And the difficulty here is, things have been changing so quickly. Early on, that it seemed to be that this disease transmitted a lot more by touching surfaces. Now it seems to be much more respiratory. So we've had, if you are opening your facilities, you may consider putting up signs, making masks. Well, masks already are mandatory at the state level, but reminding people, to wear masks. These requirements, you want to think through. Do you post a sign, fence off areas, close up certain facilities? And a big portion of this is going to be what's your insurance say, and how can you make sure you get coverage if you do end up with litigation. So with that, we want to open up for questions, and we've covered a lot of material in a short amount of time. We want to leave some time here at the end if there are specific questions people are seeing, and we can again take comments from the chat box, or if anyone has, I think we can take if anyone wants to comment over the phone. Either way, I believe we have technology for it.
Yes, and Michelle is monitoring anyone who wants to raise their hand through the icon, and then we'll be able to call you so you can speak your question. But we do have a list on the queue, so I'll begin from the top. If an LEA has a third-party vendor managing the facility use, what other concerns or thoughts should we be aware of?
Well, I don't know, Kelly, you feel free to jump in if you disagree here, but I don't know that would change any of the fundamentals we've talked about today. What it does change is you want to make sure you've communicated with your third party to let them know how. You want them to be part of the team as you're making having some of these discussions, and they need to know what your game plan is and how they're gonna. Because a lot of times the real benefit to those third party entities is we talked earlier about district gets first priority, and then the rest is first come first serve. And so the real benefit to those entities is managing those first come, first serve and what that looks like. And so I think it's just important to let them know what you've decided. And really the better option would be to make sure they're involved in the discussion. They've probably worked with other districts on this and may have some advice and some sample documents for you.
Yeah, and if I can just add to that, I agree with everything Sean just said. And it seems to me that if there's a third party managing use of the site, there presumably or should be a contract with that management entity. And so some of the contract considerations we talked about earlier that you want to apply to the user, you may want to think about how those need to be included in the agreement with the management entity so that they're passed through to the user. Because I'm not sure what that contractual relationship looks like. but you basically now have three parties involved in the relationship. And so discussion is going to be extremely important, making sure everyone's on the same page, and then also revisiting any agreements to see if they need to be modified or amended to address some of these issues.
Okay. The next question we have is, does this include administration sites, such as conference rooms, training centers, such as sites without student programs?
Yeah, again, the Civic Center Act doesn't call out specifically classrooms, and so Civic Center Act requests would apply. I think Kelly read the definition earlier. It apply to fields and to buildings, and so it would generally apply to common areas, pools, soccer fields, administrative buildings potentially. I don't know, Kelly, if you have any other comments. It wouldn't apply to areas necessarily where, some districts will limit areas where there's maybe items that may be more destructible, like a science lab. Kelly, any other thoughts here?
Yeah, I think, the statutes refer to school facilities and school grounds. And so that's not specifically defined in the statute. I would interpret that to mean, the majority of a school property. I don't know that it would apply to, say, like your district office or something like that. We're really talking about schools. But I do think there's room to limit the space within that school based on all of the different considerations we talked about. A science lab is a perfect example. With the authority that the board has to place terms and conditions of use and restrictions, I think you could exclude some of the space. With administrative space, there's of course going to be a huge confidentiality. You're going to have records in there that the public can't be going and having access to. So those types of areas could probably be excluded.
So we've gotten a few questions in regards to the fee schedule. What is the best way to raise the Civic Center fees, and what would we implement as a temporary fee schedule to address COVID considerations?
I think this is a great question, and I think the first step would be to look at your fee schedule. We have seen some fee schedules that do specifically call out, janitor fees or cleaning costs already as an itemized additional cost. There's different ways of handling, backing up here, different ways of breaking down your fee schedule. Some will break down fee for a use of a classroom per hour or per day, or not necessarily classroom, but the football field or whatever the facility is, breakdown. Others will also include, here's the fee, and then on top of that, we charge you cleaning. So if you've done that already, then you may not necessarily have to modify the fee schedule. Otherwise, it would likely take some sort of board action. And again, there's not a lot of law on point here. You could adopt a whole new fee schedule that gives you some flexibility. You could include information in the resolution saying all fee schedules are modified to account for additional janitor time. I don't know, Kelly, if you have any additional thoughts on kind of best way of modifying that. But I think some form of board action would likely be required.
Yeah, I agree with that. And I think the answer is there's no right answer here. I think there's a lot of flexibility and a lot of different ways to do it. And I agree with Sean that the starting place is looking at the current fee schedule that's in place and seeing, what is it that you want to change about that? And is it something that could be done easily through a separate action that just is going to be temporarily in place? Or do we actually want to modify the whole fee schedule? I will flag, we jumped over the fee discussion just because of time. Obviously, we only had an hour today, but just so everyone's aware, there are regulations in the California Code of Regulations that govern how you calculate the fees that can be charged. Those are at Title V, starting at section 14037. So Title V, 14037 of the California Code of Regulations. And that kind of breaks down, or at least gives some guidance as to how fees are supposed to be calculated. So I would say, start with what you have in place now, look at those regulations and kind of just figure out where you want to go. And then it's just a question of what mechanism to get you there. I think there's a lot of different ways to do that.
Great. We also got a few questions in regards to the register of voters are being insistent on using campuses, and due to COVID, we're not allowing them on our school sites for general election in November. What legal recourse, if any, do they have to force us to open our sites?
Well, again, I'll let Kelly jump in here if she has any other comments or disagrees, but early on, we talked about Civic Center Act and two different categories. There's categories of shall and categories of may, meaning some are mandatory and some are optional. The registrar of voters likely would not fall under the shall category. I mean, those are really geared towards students. That being said, I mean, they are another government entity, and I think it'd be worth having a conversation with them in conjunction with local health officials and getting, some guidance here. And ultimately, that's with the current election environment and all the talk about, absentee mail-in ballots. And, I know a lot of states and counties are looking at extending the voter time. I mean, this is a very important issue. And so I think it'd be risky to just absolutely refuse without some thought going into it.
Yeah, and I wish I had a great answer for that, because I think it's a really great question, and I have to say it's not one that I've looked at yet or heard of yet. I actually think this is not so much a Civic Center Act question, because as Sean said, that group doesn't fall under any of the users at all. I mean, certainly permissible use, but whether they might have some state or some other legislative authority that would allow them to be on campus is a question I don't have an answer to, but that would certainly be something interesting to look into, which is not my way of saying call your lawyer. I would actually say save the money and ask them for their legal authority that would allow them to do that as a starting place, and then, see what they can come up with. That would be my first suggestion, assuming that your district doesn't want to move forward with that arrangement. Interesting question, though.
And then similar on that line, what about requests for COVID-19 related use? I know that in Long Beach, one of the facilities was being used for testing. So for food collection, preparation, distribution, blood drives, PPE distribution, these all pose additional risks to staff. What about those requests?
Yeah. Go ahead, Sean.
I said same thing as Kelly's prior answer, that not really a Civic Center Act request. Counties have separate authority to respond to emergencies. And so you have a lot less discretion at that point to refuse. You can kind of set parameters, request indemnification, but if we've seen, it wouldn't be a Civic Center Act request at that point.
Yeah, I think you can tell that we're not sure of the answer to this particular line of questioning, but I do think that there may be some more authority on the other side in this category, where they may have some rights. That I don't think that means they're unlimited, and I would certainly want to see exactly what the county or others are relying on in order to say that they have right to be on the facilities. I do know one district that I work with has opened up some of its facilities to COVID testing, and they did go through quite a negotiation with the entity that was going to be doing the testing, which was not the county, it was someone else, but to put parameters on the use and certainly indemnification and all of that, because now you're actually having people who may have the virus come onto your facilities. So I would really need some very strong authority before I would ever buy an argument that the district doesn't have a right to have significant protections in place and perhaps even stop that use altogether. But again, I think the starting place for those types of uses is, decide what your goal is. If it's to keep it safe, we're asking them.
Sean, can we ask you to mute yourself?
I would suggest, if you want the answer to be no, they can't use your facility, then I would start with a request for what authority they believe they have a right to use that site, assuming that there is something out there that really does allow them to. And again, there is very strong legislative authority that allows counties to act, county public health to act in the state of emergency. So I do think it's possible they have some rights there. But I think it's probably a pretty nuanced issue. And at the end of the day, I wouldn't just allow them on the sites without some pretty significant, language in a facility use agreement, just like you would treat anybody else.
Then we got a question in regards to, is it possible to reach out to your organization to see the template of facility use agreements that Kelly, you mentioned during your presentation?
It might be. Some of those have been adopted by boards at public meetings, so they're on the internet out there. I don't want to name the particular district I'm thinking of course. So I'd have to think about that, but we can follow up with CASBO on that and see if there's something we might be able to get you, maybe at least some samples that districts have done that are actually public record.
And do you have any advice on how to move forward when custodial staff are expressing concerns of having interaction with more people who potentially could be carrying COVID? They've received various requests from their union leadership to discontinue facility use permits.
That's a really good question. I'll just respond briefly, and Sean, feel free to add. One thing that we did do with one of our facility use agreements is shifted custodial 100% onto the user. Now that's easier to do, and there may be some labor implications here that I'm probably not the one to talk to about. But we did shift the responsibility so that the particular user would handle all of their own cleaning. Of course, so that's one potential option. Of course, you want to talk to your unions about that issue and make sure there's no issue there. But I do think that there is also another potential complication, which is making sure that this outside party that's now going to be cleaning your sites is doing so in a way that meets district standards. So I think there's ways to navigate that, but each of them kind of have their own considerations.
Yeah, I would just add, for background on this one, the governor mentioned a couple weeks ago during a press conference when talking about requiring teachers to come back on campus, and he said he didn't feel comfortable making anyone do something they didn't feel safe doing. I would just mention that would likely be something that the union's going to bring up with janitor or maintenance staff that don't feel comfortable. Referencing the governor, again, it doesn't have that was an executive order, didn't have legal authority, but it kind of sets the tone of where the governor's coming from on that. So it just might be something to consider. And then want to bring up there is an election code section going back to the registrar of voters. Thank you for a participant for forwarding it, but it's election code 12283. So that'd be something to consider. As Kelly mentioned, it wouldn't be a Civic Center Act at that point, but there is a separate election code section you'd want to look at on making that available and responding to your registrar of voters.
The next question is, are we okay to suspend facility use even if the county or state guidelines are allowing gatherings similar to sports pods guidelines? Basically, can we be more strict than those guidelines?
Yeah, I don't see that would set the, bind the school district in any ways, because there are different considerations for the school versus the county. From a legal standpoint, from a practical or political standpoint, this is going to be, that might be an area where you get some more pushback on, and it's much easier to be able to punt, so to speak, on the decision of another entity. And that's when anytime you go stricter than another entity, you could face more pushback.
And is there any state level entity that could clarify some of these specific questions so that we're not open to interpretations and risking potential legalities or penalties?
The governor could issue an order, but he hasn't yet. Other than that, we could have an amendment to a new law. That's something that could be pushed for, but at this point, we're not aware of anything. So it's just, you have some discretion, but discretion also means, it's up to you to decide. So that's, unfortunately, we don't have a better answer at this point, unless you want to convince the governor to, issue a new order.
Yeah, and one other thing I'll just add is, that I think we've seen a lot of frustration, not just from our own clients, but others, about how much of a lack of clarity there is in all of the different orders and guidelines and guidance and mandates from all of the different levels of government. And so we share that with all of you. One thought I would have is whether CDE might be an appropriate a state agency to start putting down some guidance, since this Civic Center Act is an issue that is specific to school districts. Absolutely. That might be one possible lobbyist to see if we could get any guidance from them.
That's a good thing that I will bring up in a conversation I'm having later on with them. So thank you so much. I know we have a few more questions, and I think at this point what we'll do is show folks that there is contact information, and we will be fielding these questions and getting back to folks on a timely basis. And with that, thank you so much, Kelly and Sean. We truly appreciated your time. It went by really quick, so thank you so much for this information.
Very informative. Thank you.
Well, thank you. Yeah, thank you, CASBO, for inviting us and facilitating this discussion.
Thank you. And we'll get back to folks.